Page 27 get 800.
Any mention?
May it please your lordships,
Yes?
I beg to mention item number 1 from the supplementary list.
Why?
Lordship, DSJ is not keeping well.
Oh, yes, who's appearing for Mr. Chanda?
Lordship.
What's the matter about? Why is the writ petition Paris?
No, Lordship, this is a CAT order, Lordship.
Oh, against Carol, okay. Yes. Yes, as is reported that the learned DACI is indisposed. When?
After 2 weeks, Lordship.
Yes, this matter after 2 weeks, yes.
Highly obliged.
Daily list item number 1.
Made clear. So we have filed the report, my lord.
Shwaban, are you getting it?
30th interim report, my lord, and 31st has also come, my lord.
So, but I should have watched out. Yes. This you file on 15th, right?
Yes, my lord. 15th of July 2025, my lord.
Some substantial reiteration of the committee report of the 31st interim report.
31st I have not seen, my lord. 30th report says...
Sorry. Yes.
30th
and 31st. Because 31st report, whatever has transpired, because there was a meeting after the committee, I suppose.
There was a meeting.
After that, whatever transpired, the meeting suggestions given by Mr. Ahmed is... Yes.
Because coals are not being lifted. That is there.
One thing is one second. But the 31st report. Any idea
The problem. 19th June, na? This is June.
Yes.
Your lordship, the problem which we face is the Coal India has been auctioning the coal and on number of occasions, my lord. But the difficulty is that because of lack of demand in the market, my lord.
No, one thing, if you see, what happened was in the last, I think the order dated 2/6, right, of this court.
Yes, my lord.
Yes, we had, the thing is that we had seen that this coal was not being lifted, correct?
Correct.
And we had requested the committee to examine
Yes,
to
ma'am.
how
Yes.
what are other methods
Yes.
which will be more efficacious and reliable for the exchange auction of the substantial amount of coal.
Yes, ma'am.
Now the meeting has been held, correct?
Yes, my lord.
And the meeting, apart from Coal India,
Yes, my lord.
Coal India has given 4 suggestions,
Yes, my lord.
which are 3 already existing in that revised
SOP, and that is placed before the oversight committee, my lord. And one suggestion has come also from chairman independent coal auction committee in paragraph 4 of my report, my lord, of 15th July report.
Yes. Yes.
EMD suggestion to increase the EMD, my lord. 1, paragraph 4. 2, there are certain suggestions, my lord.
Yes.
And
Now you see, the thing is that we cannot be stuck in a kind of a deadlock,
yes, my lord.
whereby the coal is
lying.
still remaining and
And it is,
even the successful auctioneers are not lifting it.
yes, my lord. And bidders are also not coming for remaining coal also. That problem we are facing. Either if we reduce the price, these are all commercial issues which, my lord, committee is looking into and going into these issues.
Because about these, these large consumers of coal, like cement companies and all, if they can be in some way,
Yeah, there was a suggestion.
where they can
There was
give,
a suggestion
they can,
that
you can give them at a some discounted rate,
so they can
Discounted rate means some rate which without the,
yes, my lord.
and they can lift it because if the coals are flying, then that
Then it will
mining
go-
cannot take
it
place.
will be-
illegal mining will continue.
Yes, my
whatever
lord. And
reason.
waste will also be there,
Waste
and
will
the value will also go down because of withering process. No, we will put
Because
this.
the thing is that you see, even from the committee,
Yes, my
as per
lord.
the 31st interim report,
Yes, my lord.
so that matter still remains to be,
Resolved.
Yes.
That is the problem. Is we are also stuck in log jam. That is the issue which is troubling us also, and at the same time we have to maintain those warehouses and
Two
depot.
parts, yes. One part is that coal is lying there. The other thing is that with regard to the other coal is detected by the,
Yes, my lord, they are
by the
being-
drone survey, by the Garuda and by the
Yes, my lord. The
MBDA.
physical surveys are being conducted in respect of each lot. There are discrepancies which have been found.
or one discrepancy which has been
That the
detected.
quantity
We will
was
give-
missing.
We will give you a copy in the 31st interim report.
Yes, my lord.
where it was detected and
the quantity was missing.
Magically, when it
It
was
is vanished, my lord.
gone for
Yes, my lord.
vanished.
But what has happened, my lord? If the committee has said that wherever there is a mismatch, FIR is to be registered, and the
So now
inquiry
the deputy commissioner has been, the SP has been directed to take-
register the FIR in
But
respect
that is
of.
one thing. Now the drone survey has found these,
And suddenly it can't
illegal
vanish.
mine coal
Yes,
and
my lord.
it
Lordship is
disappears.
right. It can't vanish. Simply, I am also not believing this part, that there is something seriously missing in this entire year, because quantities are missing, and committee has recommended registration of FIRs in each case.
Smaller quantity. Yes. What to do?
My lord, kindly give me this 31st report also, because 31st report is sequel of 30th report, my lord.
31st report, in fact,
is a
because he had taken part in the meetings, correct?
Yes,
So
my lord.
31st report also, reflects what happened in the committee meeting. Only that it says that, as directed by this court, proposed submit suggestion for efficacious and reliable method for expeditious auction. Mr. Ahmed, from the part of Coal India, there's no what other apart from the suggestions you gave, but these are already part of that.
Standard operating procedure.
Yes. So we can two of his suggestions. One suggestion, fourth suggestion, you say for debarment or defaulters to participate in subsequent auction events needs to be inserted. We have to insert that in the revised comprehensive plan.
Yes, ma'am. Some deterrence, blacklisting kind of thing will be required.
That is ENF.
उसमें बहस भी नहीं मिली सबसे.
Another thing is that a clause may be inserted in future auction notices managing if full payment is not made in 120 days, or if entire coal is not lifted in 120 days,
It
full payment, the
forfeiture.
bid will be cancelled
Yes, ma'am.
and forfeiture of EMD.
Forfeiture. That process will
That the court had directed in the
earlier order also, Your Lordship has.
So today we are stuck in.
Yes, my lord.
sense,
Kindly give me one fortnight, my lord. I will also speak to the officers concerned and Coal India also. But the issue is that matters will has to be resolved somehow, because if they do not lift coal, we have to seize the AMD, my lord. We have no option and blacklist them. That we can do. There is no problem in that. And third option is whether we can give the coal on some concessional rate to bulk consumer.
Yeah, bulk consumers. Yeah.
These are the three suggestions which have.
But that concession should not be that. But that will be examined by the committee. We can't.
Yes, we
allow
can't.
for some.
We can't.
wholesale Kind of,
This is not a mechanism to facilitate something not right, not correct.
It would be for one time measure.
One time measure, but how much concession? How concession is to be
That's
given?
worked out.
All those are procedural aspects which cannot be
How
worked out.
much will you give to the Environment Restoration Fund? Then for-
MPRF and all those things.
That's the only thing. We'll do one thing then. We will take on record your status report.
Yes, my lord.
Number one. Number two is we will give you the 31st interim report.
Yes, my lord.
And what else? Yeah.
What is to be done? I don't know. Coal India
Yes,
is the only
complete
company in
down.
authority which is auctioning.
The 31st interim report
They're doing on basis of some good
filed by the Justice BP Kotoki
Okay.
retired committee has been perused, and the main concern and the main issues which have been flagged in the report is with the necessity of effect of what do you call it, of evolving a new efficacious and reliable method for disposal of reassessed stroke re-verified inventoried coal lying in the Coal India designated depots, and also for action to be taken for disposal of the illegally mined coal which has been recorded in the survey reports submitted by like M/S, Garuda and MBDA. Stop. It is noted that pursuant to the orders of this court dated 2025, meetings have been held by the concerned departments, including the CIL, to suggest more efficacious and reliable methods which were to be adopted for the expeditious auction of a substantial quantity of reassessed, re-verified, inventoried coal, etc. Stop. As reflected from the report, in the meeting, Coal India Limited had put forward 4 suggestions, and the chairman of the independent committee of coal auction, constituted by the state of Meghalaya, had put forward 3 suggestions. Stop. The suggestions so made, it appears, were discussed in the meeting, and 3 of the 4 suggestions proposed, 3 or 4 suggestions given by the CIL were in fact already incorporated in the clauses of the revised comprehensive plan of 2022 at clauses 8 bracket small j, comma 10 bracket small p and 11b. However, other clauses which have been suggested, namely 2 other clauses, will be necessary to be included in the revised comprehensive plan. That is the clause with regard to future auction notices, which will mandating therein that if full payment is not made
within 10 days.
is not made in 120 days, as observed by this court in the earlier orders, or if the entire call is not lifted within 120 days of full payment, the bid would be cancelled with forfeiture of EMD and the call will be put up for e-auction. Stop. Suggestion has also been put forward to convene a meeting with the authorized coal-based industries in the state to encourage them to participate in the coal auction process, and also for providing concessions and rate to such industries who are bulk consumers. Stop. The suggestion, with regard to the further suggestion, is also given by the CIL, has also CIL made in the meeting dated 30/6/2025, has also been recorded, where it has been proposed that the auction process be not proceeded with until all issues are resolved, and it was decided to put on hold the initiation of fresh auction process of reassess re-verified inventory coal till today. Next paragraph. It appears that the final recommendations of the committee are still to crystallize, as inputs are still awaited from the different inputs still awaited from different quarters with regard to the efficacious and reliable method for auction of the said coal. Stop. Apart from this aspect, the report, yes. Upon report with regard to the applications filed by persons claiming non-inclusion of their existing coal in the survey connected by MS Garuda, the committee has reported that only one person's claim was found to be genuine, and out of the remaining 21 applications, one person's coal was not inventory list, 6 persons' coal was not covered by the affidavit filed before the Honorable Supreme Court, and 14 persons' coal, though included in a stock of re-verified coal survey, was not found in those coordinates. Therefore, the state government, in consideration of this finding, the state respondents are therefore to intimate as to what action has been taken, as to the committee as to what action has been taken thereafter in respect of the coal of these 21 applicants, and whether any police case has been registered against persons, or whether any FIR has been lodged by authorized officer under the MMDR Act under 57, and if so, the status or the outcome is the same. Yes, another. Yes. It's also observed in the report that, next paragraph, in respect to the coal found by MBDA in Rajaju and Dingan village, according to Deputy Commissioner, inspection was conducted at Dingan village and only 2.5 tons of coal was found with some residue and traces of coal against 1,839.03 metric tons which had been recorded by MBDA in the report. Stop. Similarly, in the inspection that had been carried out in Rajaju village, only approximately 8 metric tons of coal and some residue and traces of coal were found out of 2,121.62 metric tons as recorded by MD in the report. Stop. This issue is of concern inasmuch as the same is illegally mined coal, and in spite of the detection, the unknown persons, it appears, have lifted and transported the coal. The state respondents therefore are to take urgent action in this accord and to hold accountable the persons involved, including the local police. Stop. Next paragraph. Next one, a status report has also been filed by the state to the 29th or to the 30th?
30th.
To the 30th interim report, and the same also has touched upon the steps taken by the state respondents with regard to illegally mined coal in South Garo Hills, and also the disappearance of the coal in Rajaju and Dingan village. But apart from indicating that an FIR has been filed, no other information has been given. Stop. Agent Hills. Reports, the state's report also has indicated action taken with regard to East Janta Hills. This 9012 was in the earlier report already there also.
Yes,
the same amount of coal.
Yes, ma'am.
Thomni. With regard to the coal found outside designated depots in Janta Hills. So, and the details of the inspection have been given therein. The committee, it appears, has also directed the Commissioner to verify and compare the quantity of coal against the UAV reports, and if there's substantial difference, for FIRs to be lodged. Stop. This coal-laden truck, you mean to say that it was detected that it was because breakdown shifted, the load shifted to another truck?
That is what Lordship will find at page 10, 9 and 10.
Yes. Yes. With regard to the inquiry of the infraction of the MMDR Act, with regard to the challan, with regard to the non-matching of challans and truck number, it is reported that the same was due to a breakdown and mechanical defect, that the auction coal was loaded into another truck and transported to the exit point at the way bridge at Narang, and it's not a case of an illegal challan being issued. Stop. On the issue of overloading, it is reported that necessary steps have been initiated. Stop. On the reported death of one minor in Musyang village, the report shows that the news report found to be not true. So upon the other issues, such as, what about this audit of this ferro alloy companies?
That is going on. If you Lordship will come to page 11, my lord. Page 11, bottom, my lord.
Why is not complete?
Some reports have been sought, my lord. If you Lordship will see,
Yes.
they are 300, totaling 352, representing 5% randomly selected from the verified challan were submitted to Director on 9th June, where MTCs were subsequently categorized district-wise and dispatched on 19 June to respective issuing officers for verification and details, my lord. And then with regard to so and so, my lord, once verification, everything by next report we
With
will
regard to the source of coal and audit of coke oven plants, so the report indicates that the process is still on, and the advocate general assured that on the next date the findings would be placed before this court. Stop. With regard to the setting up a smart check gate, this is a non-starter.
Yes, my lord, that is very.
It's with regard to the setting of smart check gates, the same issues or problems faced are reiterated, and it is reported that the possibility of integration of smart check gates with the custom check gates is being explored. Stop. The report also touches upon the collection of demurrage charges, of which rupees 13,49,093 has been realized till date, leaving a balance of rupees 5,01,947 to be collected, which notice and reminders have been issued. What of status of closure of abandoned mines?
My lord, the report is from CMPDIL. If Lordship will see the next page 15B.
Is it awaited?
Actually, it is placed before the technical committee of MEPRF for appraisal and forwarded to oversight committee of NGT for approval and sanction amount, my lord.
Stop. With regard to the status of closure abandoned mines, the report informs that the Central Mines Planning and Design Institute Limited and MIDC and I bracket CMPDIL and Meghalaya has submitted invoices for works executed till date. Have they started the work of?
They have started, my lord, preliminary report, if you lord would recall, but there is a final report is awaited, my lord, and
which has been forwarded to technical committee for appraisal and forwarded to the oversight committee of NGT. But however, the final report, this is a DPR. DPR is still to be submitted. As the next paragraph, as observed above, and in view of the prevailing situation with regard to the disposal of the reassessed stroke re-verified inventoried coal, still awaiting further recommendations for disposal of the same. When will this matter again? Let this matter when after 4 weeks.
After 4 weeks, my lord. That's all.
Let this matter be listed again after 4 weeks, so that the court will be apprised by further interim reports in the matter. The copy of the 31st interim reports also to be available to the respondent and other parties appearing.
And Coal India.
Yes, Coal India.
Can it be 25th of August?
Yes. 25th cannot be. 20th August is a Thursday.
25th Monday.
No, Monday no. It's only been. I sit in. Huh? That this bench only special bench 1 day a week, and that's only Tuesday or Thursday. Tuesday, 26th. Only Thursday. Any other day? 26th. Then we'll keep it on 25th, specially for you. Just on 25th.
Item number 2.
Well, it's in item number 2.
You've been newly engaged.
No, not engaged in the sense of the merits of the matter, Millets. There is something a little more sinister and heinous that has come in. Millets, for which, Millets, I have been requested to, Millets.
Sinister? What do you mean sinister?
Something very sinister, Millets. I'll just point out. An affidavit has been filed by the respondent number 14, Millets, on 21st of July, 2025.
Affidavit. 21st of July.
Ballots. This is an affidavit in reply to the rejoinder affidavit filed by the petitioner as per direction of this honorable court, passed by the order dated 26/5/25. Millets.
Yes.
My lords have it.
Yes.
Well, I would just first draw your lordship's attention to paragraph 6, Millets, at page 3, if my lords kindly have a look at it.
Yes.
Paragraph 6, Millets, 6 lines from the top.
Yes.
If my lords permit, Millets, I can read it.
Read the whole paragraph.
Millets. Preliminary to the rejoinder affidavit is totally evasive on the real issue in the affidavit filed by so-and-so. In fact, the contents of the rejoinder affidavit spells the truth so-and-so. My lords, after that, it is most respectfully submitted that the learned counsel, now my lords, start from here.
Casting person is aspersion.
Well, it's learned counsel appearing for the PIL petitioner is not only closely associated with the XMLA but is also an active associate of the participant in the illegal nexus involved in illegal miners and illegal coke manufacturers, and while misusing this forum of justice in the guise of public interest, and the attitude and materials on record reflects in doing so, has willfully misled this honorable court at every stage of the proceedings, thereby breaching the solemn duty of an advocate to assist the court and the cause of justice in the process, and has gravely tarnished the dignity and noble image of this legal profession. So it starts from here, Millets. This is not the end. Which is why I say, Millets, there's something very sinister. Next page, Millets, may kindly have a look at page 5. 5 lines from the top.
Yes.
In factual, I was detained not for illegality, though projected, but as a retaliation for exposing district administration complicity in illegal coke plants through PIL proceedings, so and so, so and so. Then, Millets, further, Mr. So and so have represented one of the syndicate members in bail, and also that case also, although is irrelevant to the present matter, and underscores the petitioner's malice and gross representation. So while he says, Millets, it is irrelevant, deliberately some name is brought in. Not over, Millets. If I may turn around, Millets, page 6, last paragraph. The petitioner's concealment of this material fact and the counsel's failure to disclose it amounts to suppression of jurisdiction. Page 6, Millets, last paragraph.
Yes, yes.
Is referring to some stay orders by the Guwahati High Court, Millets. The petitioner's concealment of this material fact and the counsel's failure to disclose it amounts to suppression of judicial orders warranting cost of abuse of the process. Millets, if my lords continue further, page 10, Millets, 4th line from the top.
Yes.
The common advocate representing the petitioner in this PIL and so, who also happens to be a close friend of so XMLA, proves coordinated misuse of judicial process. Down below, Millets, paragraph 10, 5 lines from the bottom, Millets. Mr. So-and-so, I'll read this, Millets, this is even more interesting. So-and-so, denial of so-and-so in the proxy litigation is demolished by irrefutable evidence of so-and-so in Samuel Sangha, so-and-so, both represented by the same advocate. She so-and-so, in coordinated cases attacking respondent number 14, was clubbed together with this PIL in so-and-so. And then, Millets, the advocate's deliberate ignorance of PIL number so-and-so by one of the associated with implicated so-and-so, so-and-so, so-and-so. The embargo of respondent number 4's trade stems solely from the counsel's medical emergency on so-and-so. So, on a particular date, Millets, the counsel did not appear, so that has again been brought in. Medical emergency on so-and-so, NHS so-and-so of a previous affidavit, not lapses, a fact suppressed to misrepresent bona fide conduct. And, Millets, if it goes further, paragraph 14, some photograph of the counsel, Millets, with somebody is annexed, and Millets may kindly see what is said where it is annexed. Photograph taken out of a video of Mr. So-and-so with ex-MLA of the co-conspirator available in public domain linking the co-conspirators is annexed here too. And Millets, what is the, it doesn't end there. Page 17, para 19. In response to so-and-so, my lords have it, Millets. May I just point out? In response to para 17 of the rejoinder affidavit, I would state this petitioner's denial of syndicate links collapses before irrefutable evidence. Advocate so-and-so, common counsel in PIL number so-and-so, is the linchpin of the conspiracy, orchestrating coordinated litigation to harass respondent number 14 and family members for refusing extortion demands of ex-MLA and close eyes of the counsel. His deliberate aggressive pursuing against this vendetta-driven PIL proves active complicity in obstructing justice where most of the common orders have been just observations projected by the petitioner only. This advocate-level collusion, coupled with so-and-so's admission as Samuel's cook, confirms a criminal syndicate masquerading as a public interest litigation, which I can substantiate to the events of post of so-and-so. Paragraph 20, my lords, is again there. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12. 12 lines from the bottom, if my lords kindly have a look. Advocate so-and-so, co-conspirator, distorted it as devoid of merits by suppressing so-and-so's coercion of DMR's officials to block refunds to give wrong data. Then at paragraph 21, my lords, now this is where it gets very interesting, my lords. Paragraph 21.
Yeah.
11 lines from the bottom, my lords, if my lords can have a look.
Yeah.
This honorable court's extraordinary jurisdiction under Article 226 empowers it to lift the veil of proxy litigation, summon Samuel Sangma as a necessary party, and in fact also dispel the cloud over these proceedings. This honorable court may also direct advocate so-and-so whose role transcends legal representation into active syndicate coordination to file a personal affidavit disclosing his professional personal relationships with so-and-so, 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 affirming an oath he is not a co-conspirator in the coal laundering, extortion of PIL abuse scheme. 3. Waiving any professional privileges that would shield material facts. Such transparency is imperative when an advocate's conduct is not client's confidence, and direct a probe into the syndicate where exported coal via forged invoices which has been exposed in PIL and after respondent so-and-so was sidelined from the legal trade with the help of this malicious PIL by the henchmen of the mastermind of the syndicate. Page 22, minutes. Paragraph 23. And it goes on and on, Malis. I'm just pointing out the
Affidavit.
first line, well, second line from the top. The petitioner and advocate on record are also ready for a formal CBI inquiry regarding role of so-and-so advocate and other syndicate associates of illegal so-and-so from Kaswapara for so-and-so.
Give me a
Well, it's again at page 23. Again, the name of that counsel is brought on record. Why I say this is sinister is, my lords, there is a PIL. My lords have taken judicial notice of this matter.
Yes.
Now somebody, my lords, is representing the PIL petitioner. And my lords, a frontal attack labeling the counsel as a co-conspirator and my lords leveling these kind of allegations on affidavit has been filed before my lords. In the first instance, my lords, this affidavit has to be withdrawn.
We'll hear who's replant. You are Mr. Bhama.
Yes, my lordship.
You are appearing in person. But you understand one thing. Please listen. Please listen. Whatever allegations or whatever statements he made on affidavit are very serious. See, over and above the list that is pending in this court with regard to whatever this coal matter. Now, what you have stated in the affidavit, has cast severe aspersions and his allegations are very serious. And how will you substantiate them? On what information is your affidavit based on?
My lordship, the information is based on the court reports. I have specifically pointed in paragraph, as the rejoinder affidavit with the petitioner counsel has filed. He has specifically mentioned the order which this honorable court previously gave on particular dates, and in all such orders, he is trying to misproject that the projections and the orders were passed as per the observations of the court. But in fact, if you may
see, Mr. Bhama, please don't go to the merits of the case. We are still on the allegations that you have made. Now the thing is that these are two distinct things. If you have any complaints against any counsel, where is your complaint you made for the bar counsel?
Nothing.
Have you annexed it?
Not made, Malad.
Have you annexed it that the lawyer is guilty of misconduct and has conducted himself in a manner not befitting the profession? Before you make any complaint in court on affidavit, show what steps you've taken. If these have come to your knowledge since when, you should have written to the bar counsel that disciplinary action should be taken against so and so. They have their own process of how to go about it. But see, this case, the thing is that we can't proceed this matter.
My lordship, you may kindly be pleased to constitute a committee. I may place all the reports which I do have in front of that committee. So I have been saying that since day one the PIL was instituted, that the entire PIL is misguided by the ex-MLA who is one of the conspirators of this PIL and the entire syndicate. And as such, the qualifying phrases which have been used by this honorable court.
Okay, you might have anything in ex-MLA, but how have you, stated these things, that this lawyer is a co-conspirator, that he is a henchman, that he's orchestrated this PIL, that he's misused, that he's part of the, whatever.
He's the linchpin, my lords.
Linchpin.
My lordship, it is based on the rejoinder affidavit which the lawyer has himself filed on the behalf of the petitioner, whereby, like, on page number, I'll just point out several.
Which one? File on 26/5.
We have filed any affidavit. Who is that? This one, right? This is filed by the the PIL petitioner. I don't know what is he trying to say.
Yes, my lordship. Yes, my lordship.
26/5.
The counsel himself was there, my lordship, and when the embargo was
Show me the date of that.
embargo on the company was not because something illegal was found against the company, but because the advocate was not present, and of course that on that particular day, certain documents were to be submitted, which the advocate, corresponding advocate failed to present before this honorable court. So my request is only that if a small committee may be constituted, I may give the entire facts one by one, which can go into the fact, and it will be, and as things which I have shown, affidavit will be correlated directly.
Mr. Bama, we cannot relent your request because you're making personal allegations against the conduct of a counsel in a matter. That has to be looked by a different committee. That's not for the court to rein in any advocate. The bar counsel is there to do that.
Well, it's if I may, with all due respect, without getting into the merits of the matter, well, these allegations are made on affidavit by somebody who is an accused in numerous cases.
We understand that.
Against a counsel, my lords, again, who, on the basis of which these orders were passed. Something very seriously wrong, my lords, with this kind of averments being made. No counsel will then be, my lords, willing to take up these matters and point it out. He's acting as an officer of this honorable court.
So we understand, Mr. Paul. The thing is that is not this court will not issue any orders on a committee. You have to, what do you want to do with this affidavit? Because the remarks they made there, it stigmatizes a counsel without due process. You file a complaint with the bar counsel, you withdraw the affidavit, or will impose heavy costs.
This affidavit has to go, my lords. That's my only submission before, my lords.
My lordship.
Mr. Bhama, are you taking advice of any counsel, any trained legal professional while drafting this affidavit?
No, my lordship.
You drafted on your own. You see, it should not be drafted on passion. It should be drafted on facts or what you perceive have you been wrong. You're not accused in the matter. I know you must be. You feel that you've been. You have all that injured innocence. Maybe that I've been injured in this way, and this person is responsible. But is it right to put it on affidavit? It is this court, the court of record. This will go on record. So this court will not take this after cognizance. And you want to file a rejoinder, you file a rejoinder on the merits of the case. Because this only damages your case. Apart warranting a very heavy cost. You draw the affidavit. You make up your mind. Or we're passing orders now only. You draw the affidavit.
I'll withdraw the affidavit and I'll do the briefing.
So with a word of caution, my lords, that henceforth things should be a little more careful. We shouldn't get away swayed by emotions.
We understand because he feels that they've been wronged. everyone will feel that they're wrong.
It's not
Doesn't
against
mean
the
that they ventilate their grievances.
Not against the counsel.
That is against the council or whatever. Council might do whatever do you have recourse to proper remedy under the Advocates Act?
If at all, well, isn't it?
If at all, I mean that will be examined.
Your lordships have seen the kind of language. Well, if the counsel does not appear on a day and then aspersions are cast on him, well, we can use the choicest of adjectives.
Yes. The affidavit filed by the respondents appearing in person, Mr. Yudhishthira Bhama, has been perused. Stop. Mr. K. Paul appearing for the.
Well, it's only been requested to assist.
Appearing for the petitioner has. The senior counsel has specially appeared today on behalf of the petitioner to, especially with regard to the affidavit file, wherein certain allegations have been made against the counsel appearing for the petitioner. Stop. The senior counsel has taken this court through the various averments made therein, which have cast a stigma and also will affect the dispensation of justice in regard to in such matters. Stop. Mr. So-and-so, on the objection of the court that the averments are totally unwarranted, and that if any grievance the respondent might have against any counsel, adequate alternate procedures are there to be adopted. Praise allowed to withdraw this affidavit and that the same be expunged from the records. Stop. The prayer of the respondent so-and-so is considered, and the affidavit is allowed to be withdrawn and taken off the record. Stop. However, a note of caution and warning is necessary to be recorded that personal grievances or personal grievances cannot and should not be aired in the manner as portrayed in the affidavit by the respondent here or by any litigant who is before this court, as much as the same will tarnish the image of the entire legal profession, the judiciary and the legal fraternity. Stop. When this, you can file an affidavit if you want, we'll allow you, but on merits. The respondent is permitted to file a rejoinder on merits. Yes, list on 25th August.
Item number 3.
Yes?
2 PILs on the same issue, my lord.
You have remedy elsewhere. You might have your own grievances or grouses, but not
This way.
Any mention? Supplementary list, item number 1.
Should be the last photo. Well, Lords had granted me, some time to bring that letter on record by order dated 24/6/2025. There was some difficulty that's been resolved, hopefully. You should be in a position to file the affidavit. Well, affidavit has not come, but the issue's been resolved, There was some issue with the district council.
Only that, because that's the only thing.
That's the only issue, I've otherwise heard the matter on merits. May kindly have it next week, I'll ensure that the affidavit is on record.
K. Paul wanted counsel with so-and-so, let's say counsel for his policy 327, praise allowed further 1 week's time to file an affidavit, bring record letter dated 1/9/2023. Praise allowed this after 1 week is
Highly okay.
Daily list item number 5.
Your Lordship, Mr. Ghosh is on the legs before Honorable Gujarat. The other side can start and he'll
Mr. Ghosh, my lord, they have concluded their argument, my lord.
Mr. Ghosh has concluded his arguments.
It's for us, my lord, to reply.
What matter is this?
My lord,
GST matter, my lord.
if we can start, my lord. We'll argue on the next day on your side. It's okay, no problem.
You're replying now. You're ready.
My lord, I just want to start.
Union?
My lord, union will argue, my lord, once I conclude. My lord, at least for today, I will be taking the time, my lord. It will take some time.
Moreover, Your Lordship, the learned DHJ is indisposed, Your Lordship.
So, let me start, my lord, for today, because this...
Who's the effective respondent? Union
my
or
lord,
state?
both, my lord, because state GST and union GST. My lord, as far as state is
Sorry,
concerned...
not effective reply.
Yes.
From state.
State as well as union, my lord. If I can start today, my lord, they can join in, my lord, because for today, at least I will be requiring the whole day probably.
Whole day means till 4 o'clock.
My lord, I'll try to.
I think we'll have to reschedule it. When Dr. Mozika will
Learned DHJ.
we can compress the replies within, because we've taken enough time in this matter, and we can compress in one session, the replies by.
It will not be possible, my lord, because there are many things, my lord, that has to be replied, and the kind of arguments the petitioner has provided, we need to reply to almost all those points, my lord. If I can start today, my lord, they can.
It's only an annuity and that's
Yes.
all. Yes.
My lord,
We have it together.
here, my lord, before I come to the case, my lord.
Mr. Simkan, I think we will have it. Let the comprehensive reply come, and then
My lord.
we'll close, because we've lingered this matter long enough. So, US MSR Guru. Yes, MSR Guru will record you because they are respondent. India respond number 1, right?
Yes, Your Lordship.
Yes.
Respondent number 1, 3 and
3 and
5, Your
5.
Lordship.
MSK Guru by Dr. M. Muzika for 1, 3 and 5 based on accommodation as due to the absence of the learned DSCI stop. Though Mr. Insungkwan is prepared to proceed the arguments, we are still respondents stop. Let this matter appear next week.
After 2 weeks, Your Lordship.
Let it be after a week, my lord. Otherwise, again we'll forget everything, my lord. This is very voluminous.
Okay, after 1 week, yes.
My lord.
My lord.
No point is, we try to condense the arguments also, you see.
My lord, we'll require some time, my lord.
You see, the longer arguments mean the weaker your case.
My lord, but we need to reply to all those points, my lord. They have argued for 3 days.
Yes.
Oblige.
Item number 6.
Compilation.
He also will have after 2 weeks.
Your Lordship, if the
Where
learned
Dr. Mozika?
Lordship, he is indisposed, Your Lordship.
Where are we right now with this matter?
I have to advance my argument, Miller, in these matters. And if your lordship would recall that the argument of learned senior counsel Mr. Saraf was that the notices issued by the department is barred by time by virtue of section 40, the plea is taken, Miller, 55, Miller. But my case is that the notices have not been issued under section 55 as they have portrayed. It is under 36 and 39, Milord. If you lordship would record that the basic thrust of their argument is.
We take this is give.
It was compiled.
Which item?
Compiled. Nobody.
7. Item 7.
The lordship will take because JB Textile I have shown that there are suppressions and material facts.
We'll leave it aside for the time being. Yes.
So
we'll take mega technical.
Yes, my lord.
Yes, question.
Now in the mega technical, my lord. Lordship will see what is their. Let me first place their case so that your lordship would recall. Their case is, my lord, which is emerging from the writ petition, is that they say that it is barred. Only synopsis, your lordship kindly see. There are more complicated. Quote also. Yes. If the lordship will note the synopsis, my lord, that
unless there's a notice on section 35.
Yes, my lord. It is contention of the petitioner that present case no notice under section 35 was ever issued to the petitioner company, which is condition precedent for scrutiny under of return under 39, and absence of notice under 35 most arbitrarily scrutiny of return under 39, and further issued notice under same within directing 20 days, etc. My lord, that 35 and 39. And what was also argued, my lord, that it is a violation of section 55 of the MVAT Act, my lord. That is their case, my lord. This is the whole case. There was no issue of delegation of power, etc., my lord. In entire pleading, my lord. If I can place the pleading before your lordship of the writ petition, it's a very short pleading, my lord. And then I'll take your lordship to the relevant sections of MVAT Act, my lord.
Yes, well done.
Paragraph 3, my lord. In the present application has been filed challenging the order passed by Superintendent of Tax.
Writ petition.
Yes, my lord. Paragraph 3, my lord. Okay. Because facts will be clear then. Paragraph 3, my lord. 2-3 paragraphs only, my lord. Of the writ petition of mega technical.
Yes.
Writ petition 60, Milan, is a writ petition 60 of?
No, 60, we'll look at 59, I think.
59, Milan. I have got 59, Milan. I am getting 59.
59.
Yes, Milan. Lordship, both are identical, but kindly see paragraph
3,
Milan. The present writ petition has been filed challenging the scrutiny report as well as notices for curing the defects of tax return issued by assessing authority, namely Superintendent of Taxes is Jantia Hill. Response number 3, purported exercise of power under 39 of Meghalaya value added tax. This is the notice under challenge, Milord. Now paragraph 4, relevant time petitioner was a registered dealer under the provisions of Meghalaya value added tax 2003 and possessed certificate of registration. Petitioner regularly submitted its monthly return under the Meghalaya value added tax 2003 and claimed remission since petitioner was eligible for tax remission under tax remission scheme 2006. 5. No assessment whatsoever was completed by assessing authority for the period from quarter ending 30th June 2007 to quarter ending 30th June 2017 in view of the provisions of section 57 of Meghalaya value added tax. No assessment under section 55 and 56 of Meghalaya can be made after expiry of 5 years from the end of tax period to which assessment relates. And, my lord, For the sake of convenience, section 57 is reproduced here in below. No assessment under section 55 or 56 shall be made after expiry of 5 years from the end of tax period to which assessment relates, provided in case of offence under this act for which proceeding for prosecution has been initiated, limitation as specified in this subsection shall not apply. Any assessment made or penalty imposed under this chapter shall be without prejudice to the prosecution of offence under this act in view of the limitation of 5 years provided in section 57 of Meghalaya Value Added Tax 2003. Assessment period ending 30th June 2007 to quarter ending 2017 became barred by limitation on 30th June 2022. Paragraph 6, my lord, petitioner begs to state that petitioner was surprised to receive scrutiny report of return sheet issued by Superintendent Taxes Hill for the period quarter ending 30th June 2007 to quarter ending 30th June 2017, whereby it was stated that scrutiny of returns of the petitioner company for that particular quarter was completed in the purported exercise of power on 39 of 2003, and it was further stated the unit of petitioner was no longer eligible for Meghalaya remission and anomaly has been noticed, my lord. So this was the scrutiny report, my lord. Then 7, petitioner was surprised to receive impute notices same date of Superintendent Taxes for curing defects of tax returns pertaining to period from 30th June 2007 to 30th June 2017. In this said notice was pointed out certain mistake in return were detected, thereby directing the petitioner to cure the defects and make the payment of extra amount of tax along with interest 20 days from the receipt of this said notice. 8. The impugned scrutiny report and the impugned notices issued by Superintendent Taxes being absolutely illegal, without jurisdiction, being arbitrary, violative of principle of natural justice, having passed over the period of limitation, etc., my lord. Now section 35 is referred, my lord. I will place that section separately, my lord. And if your lordship will see the contention at the bottom of page 14, my lord, just paragraph 10. Subsection 1 of 35 provide that tax payable under was to be paid in the manner prescribed in the act at such interval as may be prescribed. Subsection 2 provides every registered dealer shall in the prescribed manner furnish such returns by such dates to such authority as may be prescribed. Subsection 3 provides that any dealer other than registered dealer referred shall, if so required by commissioner by notice served in the prescribed manner, furnish return in accordance with subsection 2 of section 35 of the act, my lord, and 39 is quoted, my lord. So then the whole case is, my lord, entire case is that the assessment and scrutiny is barred by section 57, my lord. Now my case is that, my lord, my defense is that the entire exercise has been carried out in terms of section 35 and there is no time limit provided in section 35, my lord, and therefore it is not barred by time, my lord. That is will be apparent from the first. Let me place some documents, my lord.
So section 57 will not be attractive.
Yes, my lord. Section 57 will not be effective, and if your lordship will see, because I have marked the other one, the notices, my lord, which was issued 343, my lord. 343, my lord. Of this one or my lord, kindly see this is.
But I think Dr. Saraf had submitted last time.
Yes, my lord.
That this case is identical, similar to the Tripura case.
I will deal with this aspect. I will deal with that aspect also, because first argument is, my lord, that Dr. Saraf's first argument was that the notices scrutiny is barred by section 57 because period prescribed.
Regards to the parameteria section 57, the Tripura case had dealt with it.
Yes, my lord. Because what was happening, my lord, if you address the wrong issue, if you pose the wrong question, you will get wrong answer. When my case.
First issue was that the conditions were not satisfied.
Were not satisfied, yes.
If your lordship will, because conditions for submitting this, if your lordship will kindly see the returns and the revised return, my lord, page 27 of the writ petition. Copies of return for period from quarter ending 30th June 2007 to quarter ending 2017, my lord.
Yes.
And lordship will
27, correct?
Yes, my lord. So this is 27. Your lordship has
Quarterly.
These are the returns which have been filed by the registered dealer time to time, my lord. And these returns are filed up to, your lordship will find 302, my lord.
Is all the returns till 302?
302, my lord.
Which years are these?
From 2007 to 2017, my lord.
Okay.
If your lordship will
10 years.
Yeah, 10 years. They have the return is
from Annexure 1.
Annexure. This is Annexure 1, my lord, and it goes up to 302, my lord.
Yes. Page 27 to 302. Yes.
302. Your lordship has, and then
30C.
Yes, my lord.
Yeah. Yes.
This is the returns and challans paid time to time, my lord. Then your lordship will come to Annexure 2, my lord.
Yes.
The assessing authority, my lord. And if your lordship will see Sri Manoj K. Verma, after fourth line, quarter ending 30th June 2007, page 303. Lordship got the page 303. And dealer's name, Mega Technical Engineer, address is this, circle is this. Yes, my lord. Date on 8/3/23, my lord.
Yeah.
Return is scrutinized under section 39 of MWAT Act. Lordship, note, kindly mark this 39 of MWAT Act. Finding dealer dealt in manufacturing and sales of cement and cement clinker. Return is scrutinized against account produced. Turnover as per the account produced was found to be 1,69,64,000, which is tallied with return submitted. Purchase and sales were vouched for and recorded in detail. No ITC claim was found as per declaration in the monthly return. Unit being eligible under Meghalaya's 2006 up to 10th May 2014, scrutiny of return was done as per government notification dated 24th May 2017, which allows 99% remission with effect from 1/2006 to all engineers. Hence, the scrutiny was completed under. So, after scrutiny, my lord, scrutiny was completed, and this is scrutiny conducted by assessing officers, superintendent of taxes, my lord. Similar scrutiny, your lordship will find for next quarter, my lord. The quarter-wise scrutiny is carried out by the assessing officer, my lord, who is superintendent of taxes. And this was carried on 30/11/2013 for this scrutiny from entire period, my lord.
Where you get the date?
Your lordship your lordship will find the date in the first page only. Your lordship will find 303. Your lordship will find that
you see date 8/3/23.
8/3/23, my lord. Say next also 304 8/3/23.
Right.
And period is also, if your lordship wants to know the quarter ending 30th June, 30th September, 31st December. This way, my lord.
December.
Yes, my lord. Every quarter scrutiny was carried out.
Yes.
Up to, if your lordship will see the last quarter, your lordship will 3/23. So this is the various quarters, and it ends, my lord.
Annexure 2. It's under section 39.
Yes, my lord. Under section 39. Now the case which is set up before your lordship is that it is barred under.
1 second.
Section.
It's gone until page.
Yes, my lord. That statement your lordship has seen.
Up to page 343.
Yes, my lord. 343. These are the basic facts, my lord, of the case, my lord. Give me the counter. And then your lordship kindly see my counter. Page 2, my lord.
1 second. Now annexure 3 is tax return. Yes. So some substance, that is the returns and scrutiny.
Yes,
for the relevant periods.
Yes, my lord. Return and scrutiny, my lord. So that's a basic short case before your lordship. Whether I could have, whether I am vested with the power to.
1 second. affidavit.
With the section. Funded by additional affidavit. What are you going to do with additional affidavit? Now, my lord, kindly see the act. Oh, sorry, counter, and then I'll place the act, my lord. Page 2, my lord.
Mere reading.
Yes, my lord. Paragraph 3, page 1 first. The answer denies the averment made in paragraph 3 of the petition, and reply would be state the respondent has completed the assessment of return provision 45(9)(2) of the act, hence is no action answering respondent. Now second paragraph, my lord, of page 2. That respondent 3 has initiated proceeding for the tax period from 1 so and so. This is second, you have given 59, give me 59. So, my lord, the stand in 59 and 60 is identical, my lord. Was duly received by the authorized representative petitioner Sri Manoj Kumar Verma, and the said person who had affixed the initial as acknowledgement to such receipt. Subsequent to receipt of such notice, writ petitioner had complied with the terms of such notice on 19/10/2021 through the same person Manoj Kumar Verma by submitting books of account before the authorities and photocopy of the note sheet containing the signature of the. So, my lord, notices were issued, my lord.
Please slowly.
Sorry, my lord. Yes, my lord. I'll read paragraph 2, my lord. Paragraph 2. That respondent number 3 had initiated the proceedings for tax period 1/5/2005 to 31st December 2016, wide notice bearing number so and so dated 27th April 2017, which was duly received by an authorized representative of writ petitioner by the name of Sri Manoj Kumar Verma, Assistant Finance Manager Account, and said person who has
I think reading a different affidavit.
Yeah, different affidavit, my lord. This is.
The juniors are not being very faithful to you.
Because the basic issue, my lord. Yes, my lord, I have written basic. 59, my lord. Kindly see paragraph 3, my lord. I'm sorry, my lord. Paragraph 3. Answering respondent denies the averment made in paragraph 3 of the reply would like to state section 39 of Meghalaya Value Added Tax provides for scrutiny of returns which state for each and every return in relation to any tax period, my lord. My case is that for any tax period furnished by registered dealer to whom the notice has been issued by commissioner under section 35 shall be subject to scrutiny by the assessing authority to verify the correctness of calculations, applications of correct tax and interest and input tax credit claim therein, and the full payment of the interest payable by dealer during such period. Clause 2 of the section provides that any mistake is detected as result of such scrutiny made by the provisions of subsection 1, the assessing authority shall serve the notice in the prescribed form on the dealer to make payment of extra amount of tax along with interest as per provisions of the act if it is payable by the date specified in the said notice. Mere reading of section 39 makes it clear that scrutiny is allowed for each and every return in relation to any tax period furnished by the registered dealer, and during scrutiny if any mistake is detected, assessing authority is allowed to serve notice upon dealer to make payment of extra amount of tax along with interest by the date as specified in the notice. It is pertinent to mention herein that as far as scrutiny of return and demand of extra payment of amount to be paid by dealer in view of section 39 is concerned, the assessing authority has very large scope as section 39 does not provide any limitation period for scrutiny of returns, and such scrutiny of return is permissible for any tax period. Hence, notice was served upon the petitioner being a registered dealer to produce the books for account on 27/4/2017. Therefore, notice issued to the writ petitioner for curing defects in tax return is legally sustainable and cannot be termed without jurisdiction and violative of principle of natural justice. Opportunity was afforded to writ petitioner wide notice dated 27/4/2017. My lord, the second part is notices were issued, my lord. Photocopy of notices, if your lordship will see, those notices are at Annexure 1 series, my lord, where notices were given to Mega Technical, my lord. Page 14 is the typed copy. Yes. With reference to subject cited above, you are hereby directed, reminded to produce in the office undersigned books of account. Notice below the period from ending 1st May 2005.
Sorry to interrupt.
Yes.
The only argument, if we understand it correctly,
yes, my lord,
is that the prerequisite of instituting a proceeding under section 39.
Yes, my lord.
will only come if there's a notice under section 35. Section 35.
Yes, my lord.
That is some substance, I think, of Dr. Sar's
That is the first argument, and second is that.
But if you want to bring in 35.
Yes, my lord. So now kindly see 35.
Yes,
35.
before 35.
Before 35, my lord, let me show the scheme of the act so that 35 can be construed in correct perspective, my lord. Kindly see section 2(7) of the MWAT Act, my lord.
That's annex where?
Meghalaya, where is the compilation? We have given the my lord,
compilation.
Compilation.
Some mistake compilation.
Amendment and everything, my lord.
Oh, now this is a fresh compilation.
Yes, because last time there was some problem in the provisions and laws, my lord. But your lordship, kindly see the assessing authority.
Okay.
Roman is definition section 2 subsection 6, my lord, and subsection 7, my lord.
2
section 2 subsection 6
2 6
SECs, your lordship, first page 1.
Yes.
SSCs means any person by whom tax or any other.
I have SSC, I have SSs.
Yes, my lord.
Wrong spelling.
Yes, wrong spelling. It should be SSCs, my lord.
Yes.
But we are concerned with 2(7) more, my lord.
2(7), okay.
2(7). Assessing authority means any person not below the rank of superintendent of taxes authorized by government or by any authority empowered by the government to make any assessment under this act. So assessing authority is, my lord, superintendent of taxes. The notices have been issued by superintendent of taxes. Those notices pursuant to which books of account have been submitted have not been challenged, my lord. Your lordship, notices have been issued to the SSC by the superintendent of taxes to produce the books of account, my lord. So those notices, the jurisdiction of the assessing authority has been accepted, and pursuant to acceptance of jurisdiction, the books of accounts have been produced before the assessing authority, my lord. That is the first point, my lord. And assessing authority under the act is superintendent of taxes, my lord.
Okay, as per section 2(7).
2(7), my lord. Now, commissioner is also important, my lord. Where is that commissioner?
Yes.
Commissioner is, your lordship will find a small Roman 11 at page 2, my lord.
Yes, commissioner.
Commissioner means commissioner of taxes appointed under subsection 1 of section 25. Are deems to have been appointed under section 116, my lord. So definition of commissioner is already there, my lord. Now kindly come to chapter 4, my lord, at page 18, my lord.
Appellate and revisional authorities?
No, my lord. Chapter 4 is taxing appellate and revisional authorities and enforcement branch, my lord. The head title of the section 25, my lord. For carrying out the purpose of this act,
yes,
the state government may by notification appoint a person to be commissioner of taxes together with such office persons to assist him as it thinks fit, and may specify the area or areas over which they shall exercise jurisdiction. Two persons appointed under subsection 1 shall exercise such powers as may be conferred and perform such duties as may be required by or under the act. So then the state government has been conferred with the power to appoint the commissioner of taxes and such other officers to exercise the power, my lord. Now 26, my lord. Subject to such restrictions and conditions as may be prescribed, the commissioner may, by order in writing, delegate any of his power under this act to any person appointed to assist him under subsection 1 of section 25. Notwithstanding anything contained in subsection 1, the commissioner may transfer any matters, my lord. We are concerned with that delegation can be conferred by commissioner, my lord. So this is the power of the, and then, my lord, important provision is appellate authority, my lord.
27.
27. There is a state may authorize an officer not below the rank of assistant commissioner of taxes under subsection 1 of 25 to exercise power and perform functions of the appellate authority under section 65. Why I am reading this section, my lord, is that there is a alternative efficacious remedy also, because the reason is that if the procedure is prescribed in the AMVET Act,
Statutory remedy.
You have to exhaust your statutory remedies. The judgments which have been cited are on the ground of limitation, that my claim has been barred by limitation, and therefore limitation is a jurisdictional question. Since jurisdictional question, this honorable court in the remedy of writ jurisdiction can enter into or examine it. But your lordship, it is not, if it is a plea that is a procedural violation, the remedy is before the appellate authority, not before this honorable court in the writ jurisdiction. So the appellate.
Yes.
Then, my lord, 29 is appellate tribunal. After that, my lord, revisional authority is also there. Commissioner of taxes appointed under subsection 1 of section 25 shall not exercise the powers and perform the functions of revisional authority under section 66 and section 67. Then appellate tribunal, Meghalaya Board of Revenue shall be appellate tribunal. So there is a entire scheme of mechanism which provides for filing of challenging the order of assessing authority before the assistant commissioner. After assistant commissioner, revision can be preferred before the commissioner, and after that also, if there is a revision, is appellate tribunal is also constituted, my lord. So before approaching the writ remedy, my lord, now, my lord, the important section 35, my lord.
Yes. Yes. 35.
The tax payable under this act, page 30, section 35 is at page 23, my lord. The tax payable under this act shall be paid in the manner hereinafter provided at such interval as may be prescribed. So this is a charging section, if I understand correctly, my lord. This is a charging section under which tax.
Yes.
And 2, my lord, every registered dealer shall in the prescribed manner furnish such returns by such dates and to such authority as may be prescribed.
Yes.
Kindly mark 3 things, my lord. 1, a registered dealer. This applies to registered dealer in the prescribed manner. Then by date, such dates, and to the authority as may be prescribed. It is not in dispute that those returns have been filed before superintendent of taxes, my lord. So he is the authority.
Yes.
He is the authority, my lord. What is he required to do when the returns are filed? Whether he requires order of commissioner for scrutinizing those returns, or he can do it on his own, my lord.
Yes.
That is, if so, and the subsection which was emphasized in the argument by learned senior counsel for the petitioner, my lord, was subsection 3, my lord. Any dealer other than registered dealers referred to subsection 2 shall, if so required by the commissioner, by notice. So we are not concerned here with, my lord, subsection 3 of section 35, my lord, because it is a case of a registered dealer. It is writ petition also. Pleading is that I am registered dealer. Returns have also been filed, your lordship. Has
distinction here.
Yes.
That any dealer other than registered.
Other than registered dealer, because there are 2 types of dealer. One is registered, one is unregistered.
Yes.
So for procedure for registered dealer is separate, unregistered dealer is separate, and that is why the subsection 3 says any dealer other than registered dealer in subsection 2. So the class of dealers who are registered is covered under subsection 2 of section 35, my lord. So this, in my submission, according to me, my lord, subsection 3 has no application. I will read it slowly again, my lord. Any dealer other than registered dealer in subsection 2 shall, if so required by commissioner, by notice served in the prescribed manner, furnish return in accordance with provisions of section 2. So when a dealer who is not registered, then commissioner will issue notice and Sub-return, Milord has seen in the writ petition 59, these returns have been filed by the petitioner on their own. If your lordship will see the return also, and notice quarterly return for the value. So this is in the form 5. This is in the form VAT return. See Rule 11, Milord. And these returns have been filed, Milord. Where is the question of invoking, Milord? I put this question to that notice by Commissioner, Milord. You are a registered dealer, you have to file it within subsection 2. Every registered dealer shall in the prescribed manner furnish such return by such date to the authority may be prescribed. Under the rules it is prescribed, and if your lordship will see page 27 of the writ petition. In the writ petition itself, the form 5, rule 11 is mentioned, Milord. I put a question to myself, Milord, whether, and your lordship will notice also that page 55 also, page 55, if your lordship will notices the returns are signed by the Supreme.
In the compilation, which page is it?
I am sorry, not in compilation, in the writ petition 59, Milord.
No, in the rule, where is rule 11 stated?
Rule is there, Milord. The rule is, your lordship will find
page.
Rules are also there. Page 68, Milord.
Of the compilation.
These rules are there, Milord. I'll place that rules also, Milord.
Yes, cursory.
Because
let us have a look.
Your lordship may have the look at rule along with rule form rule at page 27 of the writ petition. Where?
68 you said, no?
Yes, Milord. 64.
64. Draft. Oh, this is a draft rule.
We have got it from the website, Milord. It is written draft only, but it is rule which is final rule, Milord. And chapter wise separate rules are there. We are concerned with, Milord, rule 11.
Books of accounts.
Yes, Milord, books of account. That is there in the
okay, return be filed quarterly.
Yes, Milord.
Such dealers in form 5 of.
And that is why quarterly.
I'm just seeing whether there is any distinction between your dealers and registered dealers, but it does not say anything. It just says the return be filed quarterly by such dealers.
Your lordship is reading which page? I'm sorry.
Page 76.
76.
11. And this rule 9 there deals with levy composition. Okay, fine, that's different. Page 76 of your compilation.
Yes, Milord. 76. I'm there. Books of account to be maintained by dealer for making payment of composite tax. Because they are because if your lordship will see, this is for the purpose of section 17. Now we have to see, Milord, for the purpose of
because filing return. See, the thing is the return be filed quarterly such in form 5.
Yes.
Now you see page 27 of the petition. This is a form 5 application, correct?
Yes, Milord.
Yes.
This is form 5, and form 5 will be, Milord. The lordship will find form 5. Yes.
Form 5 at page annexure 1, page 27. So all the returns are filed under form 5.
Yes, Milord.
Yes, but then okay.
So the issue before your lordship is that under the MVAT Act under section 35 subsection 2, registered dealer is required to file the returns, Milord, within a stipulated date. There is no requirement of notice, Milord, by the commissioner, and it has to be filed before the assessing authority. If your lordship will just see the writ petition 59, they have filed and they have got the acknowledgement from the assessing. Acknowledgement and stamp is there, a legible stamp, and everything is there at page 39. If lordship will see page 39 of the writ petition. Superintendent of Taxes, Jantia Hill District, Jovai, Milord, page 39, 41, 43, 45. They are all received by the assessing authority, which I have shown in section 2 Roman 6 of the Act, Milord, that he is the assessing authority before you have filed return. There is no dispute on that.
Yes.
There is no iota of doubt that the returns have been filed. Notices after filing the return, notices have been issued. After notices, you have filed the books of account. to the assessing authority, my lord. Now kindly come back to this section again, my lord.
Anyway, yes.
Every registered dealer shall in the prescribed manner furnish, because I have shown the averment, my lord. In averment, it is case that I am a registered dealer.
Yes.
Shall in prescribed manner furnish such return by the such date and such authority as may be prescribed. Now, my lord, sub paragraph 4 of 35. Before any 3 I have already placed, my lord, it is applicable to other than a registered dealer. 4, my lord, before any dealer, and that requirement of notice to the commissioner. 4, before any dealer furnishes a return under by subsection 2 or subsection 3, he shall in the prescribed manner pay into the government treasury or the State Bank of India the full amount of tax due from him under the according to such return, and shall furnish along with such return receipt of from treasury a bank showing paying of such amount, provided the registered dealers are subject to
Under the according,
because he will file return as per his own self-assessment tax, my lord.
well, the sentence doesn't make sense.
Yes, my lord, there is some typo error here everywhere, my lord. Shall furnish along with
Copy this away. And paragraph away. Copy. But then Mr. Manta's book also is not very accurate. So, let's just check.
It's a very difficult task one.
It becomes very difficult, yes.
Very
Because
difficult. And in taxing statute, one word here and there makes a lot of difference.
Yes, let's see 35 out here what it says. Same thing under the recording. 1 second, just give us 1 minute.
Yes, yes, my lord.
No, it's wrong. Recording. Yes, it should read as, where's your copy?
Yes,
it should read as, it should read as, where's that 35? Before, you're reading this one, before any dealer furnishes a return,
yes,
requires subsection 2, subsection 3, he shall prescribe manner pay into a government treasury or the State Bank of India the full amount of tax due from him, due from him under the Act.
Under the
Act, according to such return.
Yes, my lord.
And shall furnish along with such return on receipt of treasury or bank showing. Now these amendments have not been inserted here. Or this is this is the latest one.
Amendment is also, my lord.
That's fine. But it should be according to him.
6810.
Amount of tax due from him.
Yes, my lord.
Under the Act is missing.
Yes, my lord.
Under the Act is missing, and under the Act is missing. Under the Act is missing, and comma it comes.
Yes.
Then according to such return, yes. Then comma is a small a only. According to such return, and according.
Yes, my lord. Everything is hang. My lord, that amendment you also will find at page 118 of my compilation, my lord.
Yes, but even the
118 and 119, my lord.
Yes. Where is it? From under the Act, comma, according to such return, comma, and shall furnish. According to yes, see. Before he left his return to file section 2, so he shall prescribe manner pay into government treasury. So also, other authorized one, full amount tax from him and the Act. According to such return. As per the return, the full amount of tax should be and shall furnish along with such return receipt treasury. But that's one under the Act missing. Under the Act missing. Yes.
Yes, my lord.
How I mean, like in this when these is typed out or something, when it's uploaded, why there are so many mistakes?
There are so many mistakes, my lord. I will try to, if your lordship permit, then I will try to get the gadget notification. Gadget notification.
Because trying to understand the
yes,
matter,
yes,
the right perspective, and if we are faced with,
this kind of challenge. Yes, my lord,
different with the section
I'm
makes
also having,
sense.
and I asked the officers to send me the gazette notifications, and they are all sleeping. Most of the time they are sleeping. That's a very unfortunate. And
We
this,
will summon them here.
because I told them send me the gazette notifications
Yeah, that's
at
what
least.
we need.
And from my office they are downloading it from the website, and this is tax matter, revenue matter, high stake is involved of the state.
Well, John, at least we
I'll-
faced the same situation last time.
Yes, my lord. Yes, my lord, because I understand that word here and there will have a lot of bearing in the interpretation. But the basic case, my lord, basic case is that there was no notice by the commissioner. That requirement, in my humble submission, is not
required.
Not required. Assessing officer is competent to scrutinize. He has scrutinized it. You have cooperated in the scrutiny, and then thereafter, you have been asked to pay the tax which you have evaded. And if you are not satisfied, please go before the revisional authority, appellate authority, and follow the process of law. Well, you can't jump the queue. Now Mr. Sinkan is providing the gadget right now. Yesterday also didn't.
On the formula, but even in that formula, we never have seen extra so they are taking shelter of 35. Saying that we are a leader. So first form the final form 5. And first form so all the rest of the issue. So it's also my space. I'm not seeing people right now. Yes.
So the point which I was making, my lord, I have got now the gadget. This is the latest gadget.
So kindly pass over the copies to us.
Yes, my lord, the copies. My lord, this
copy has not been made.
copies have been made. Copies.
But the Gazette notification should be available online. It's not available.
No, it's not
available.
Why is that?
Many of the gazettes, my lord, those are not there in the public domain, and moreover, some of them cannot be downloaded, my lord. There has to be some sort of direction from this court, my lord. And very important notifications, gazettes are not there, my lord, in the.
And under the RTI Act, they have to. The government has to maintain the entire.
The old Advocate General's office we had acquaintance with in my practice days was that every gazette
used to come.
Every gazette, it comes weekly or monthly.
Yeah.
It comes to the office of Advocate General, and that's catalogued. Is kept, those if it deals with posters and postings and transfers and all is kept aside. But any amendment
in the
or any notification that's important or any ordinance also for that matter is kept in one volume and bound.
My difficulty is for last 7.5 years I've been because every Advocate General has the separate office, separate library, separate thing in India. Except Meghalaya, and I have been asking them for 7.5 years, and they have not been doing.
Maintain your library.
Yeah,
Number one, you have to maintain your establishment. But these gazette notifications,
everything should be there.
All notifications dating back
to. It's like I am one man army.
Pre-constitutional.
one man army where I have been fighting on, because it is causing a lot of heavy toll on me also because of all these. Non-cooperation of the government.
Sometimes, my lord, those gazettes which are there also, they have deactivated. It cannot be downloaded, my lord.
What is going on?
No,
so
whatever it is, the thing is that
we have to put our house in order.
Copies of the gazettes should be there.
Yes.
And so where they can throw those, like I said, transfer postings, other things which are material. But in regard to acts which have or notifications, that is the thing. Yes. Yes, Dr. Saraf.
I was aware that the Supreme Court said that making the budget will not be sufficient. It must come to the public domain.
Public domain. They say it's in the public domain, but they can't print it for some reason.
That is very unique to Meghalaya.
How will it?
Sir, one thing I want to clarify with that.
Yes.
I will not disturb the Rani regime. Mr. Rani regime again submitting the affidavit is there. If the prosecutor finds section 65 of him,
We'll come to that part also. Right now, to
I am not disturbing at all.
I'll come to that part also. But this is not also cut. This is
proofreading is not done also.
Cut side, not complete. So that we have to ask them to give me the proper copy.
And T is become F. What is the digitization of the records? They all be digitized, correct?
Yes, my lord. That is why we get all this. We have downloaded, my lord, this compilation from the net only, from the government of Meghalaya's site only.
I think you should flag it with them.
Yes.
The large scale corrections are necessary.
Yes, my lord. And it's better to place the gadget without, in Government of India, we get the entire gadget. In Government of India website, we go and get the gadget. We get the gadget of all acts, my lord. Even the regulations which are there. Because if we have to promote transparency, at least we should have the certain times what to do. Sometimes I can write, I can talk to them, I can push them. That is what I have limited power to do.
Very prolific judge, this person.
And the gadget also which Mr. Sincon has handed over, this is also there cutting.
It's
not complete.
Carries the same
Amendment will not be there.
And now it's not. This act is no more. Its
act is gone, my lord.
It's gone. So we just. Anyway, do one thing. You conclude the arguments on next date.
Yes, my lord.
We will try to just get, because we'll have to understand. Please understand that part, that the word "the act" is missing.
Yes, my lord. The first part, first submission.
Everything hinges on 35.
Yes, my lord.
It's very important that we dwell on that.
Yes, my lord.
And if we can bring authorities, whatever.
Yes, my lord. 35. Don't do that.
Yes, I'm not sure.
Sankovi. One more.
Because this is not complete again.
Yes, the hearing inconclusive?
Yes.
Just for further hearing on?
After 10 days, my lord.
After 15 days. Very confusing.
The thing is that two things which will definitely again and argue. Ultimately, there is no remedy at all. I can sort of be lawsuit for the section itself. Because my LG has placed the section 27, which is constitutional that but section 65 is that against which order the appeal will lie. And that is only against the order of assessment. There is no appeal against the order of school being. You also find it.
No, we will examine that. Yes.
Because this matter will not regulate, will be continue because the next case something difference will be there. So it will matter not if you not just consideration that.
We'll meet all the challenges, including whether revision is there or not. I am advocate assisting the court.
Yes, we are learning,
Learning. It is all.
Every time we learn something new every day. Everything we still on a learning curve.
Beauty of law is this only. Beauty of law is this only.
Yes.
Beauty of law is this one.
Item number 9. Your Lordship, there's an interim, Your Lordship, if the interim may continue.
Yes. Further hearing, interim orders when it shall continue. Yes. That's recorded.
Actually, Mr. Bora was here in the morning.
Who's Mr.?
Bora, PK Bora.
Don't expect Mr. Bora to be around after 1. He's a busy man. Yeah. Just after 2 weeks, yes, as the counsel of the appellants not present.
Impression on your part.
May I please, Your Lordship? Your Lordship, I beg to mention for one unlisted matter for tomorrow, Your Lordship.
Why? What unlisted matter?
The matter pertains to administration of Ilaka, Your Lordship, whereby under Section 3, the power lies with the same, Your Lordship, for formation of a new village. Now, Your Lordship, the Executive Committee had delegated the power to the Dorwarshnong to hold a public meeting, Your Lordship. So as per the order, they were supposed to conduct the meeting by the end of July, Your Lordship. So we are saying that the meeting might happen on Saturday, this Saturday, Your Lordship.
Yeah.
Please, Your Lordship, I beg to mention item number 16.
1 second, yes. Item number 16, Lordship. 16? Yes, Lordship. To the other side. Your objection?
Nothing, my lord. Since Mr. Mojika is
not well, okay. 2 weeks, 1 week.
2 weeks, Lordship. Highly pledged, Lordship. A similar prayer for item number 22, Lordship.
20?
22.
23?
22, Lordship.
Yes.
Highly pledged.
Yes.
I should like to mention item number 21, Lordship.
21 is that matter where the...
No, Adjournment 21. Where's the agreement?
Lordship, just for the percentage of payment yet to be settled, Lordship, with the private respondent.
How long will it take to settle?
Just one more week,
More than a
Lordship.
month has been taken.
It will settle.
Not yet. They have not taken us into confidence.
Let it go on, otherwise...
It will be settled, Lordship. It's just
When?
for
By tomorrow?
just 1 week's time, Lordship.
When was the last time? What
About 2 weeks back, Your Lordship, they had prayed for time for signing the agreement.
We've been sending the agreement.
You can't hold the bank and just, go ransom.
We've been sending the agreement back and forth with the private respondent, Lordship. Just
back and forth, meaning?
Just
But
for a
not with us,
percentage.
Lordship.
Just
We are
the
not
percentage of payment, Lordship. We want to pay the loan. We will be paying, Lordship. Just the amount of...
Next week.
Obliged, Lordship.
Like-
1 week, yes.
Your Lordship, this item number 20 is there, Rajiv Jeffrey Mautha, which pertains to these people have been regularized by the cabinet approval, Your Lordship, and a similar matter has been sent for reference, mediation. That is item number 38. So we were thinking that a joint...
38 from this list has been sent for mediation?
38, item number 38, Your Lordship. It's a similar, pertains a similar matter.
No, the thing is that we will...
So if this can also be sent, perhaps we can make an attempt at settlement. Most of the things have already been granted to them.
But so
Only one point.
aspect remains, Lordship, that is that the petitioners who joined since prior to 2007, they've been placed at the bottom of the list, and those who have joined as recently as 2020 and 21 are placed above their seniority list, Lordship, and that will hamper their promotional aspects.
Of course. So you were sworn on mediation?
Lordship,
will your people come?
I'm not sure, Lordship, because this aspect, if the government agrees...
Will the people... See, mediation means two sides. It's not a question...
Both the parties have to be present.
It's not a question that you have to...
Only difficulty would be that...
You try to sort it out. It's not a question of, if it can be... Otherwise...
They are placed in different places, Lordship. So, 34 petitioners are there, Lordship.
34 petitioners are here?
Yes, Lordship. 34 are there.
Only adjourn it for now. Let's see what the outcome is. 2 weeks. Yes.
May please, Lordship. Your Lordship, I beg to make a mention of item number 18, Your Lordship.
Yes.
I pray for 2 weeks' time, Your Lordship, as the conducting counsel is on sanction list, Your Lordship.
No objection, Your Lordship.
Yes.
Similar prayer for item number 19 also, Your Lordship.
No objection, Your Lordship.
Yes.
Lordship, I beg to mention item 15, Your Lordship.
Item?
15.
Sostomoni coach.
Yes, sir.
Part heard? No.
Lordship, I pray for 2 weeks'
Not yet,
time.
Your Lordship.
What's the matter about?
There is a consultation of Pata, Your Lordship.
Why ask for 2 weeks? Why 2 weeks?
No instruction, Your Lordship.
We have no instructions.
No, Your Lordship.
What where's Mr. Dev? Can't be disposed of?
Your Lordship.
It's essentially a dispute between the petitioner and private
Yes,
parties.
what about private respondent? You ready with the matter today?
Regarding cancellation.
Why not ready?
of Pata. I think there is a stay.
Who's asked for time?
We don't have much to say
Yes, then-
except to say that
Just adjourn for who's your leading counsel, Mr. Chakreso? Yes, Mr.
So
Dakhar.
we were informed that it will be taking some time, Lordship. That's why we were not prepared to do Lordship. So
Yes, 1 week.
1 week.
Please, Your Lordship. Lordship, I also beg to mention item number 1, Your Lordship.
Number?
Number 1, Your Lordship.
Number 1 of which?
Of the daily list, Your Lordship.
Of the?
Of the. Sorry.
What number 1?
Of the daily cost list, Your Lordship.
Yes?
Of the daily list, Your Lordship.
Mr. Dakhar, you instruct him that you can't make mention of part 1 matters.
my apologies.
He is in your
Lordship.
chamber.
My apologies, Lordship. Then? So this is admission matter, Lordship. My apologies.
Yes, no, you instruct your juniors, your junior colleagues.
Supplementary list, item number 1.
Yes,
May I please, Your Lordship, I filed this for review. Your Lordship, in the contempt case, Your Lordship, what happened? Initially, the Apex Court has decided on, as well as on August 22nd, that the house rent, medical allowances, winter allowances, hill compulsory allowance will be entitled by the Petitioners Association, Your Lordship. So that order attained finality. Since the show cause they have read, when they read the show cause by the contempt, then when he was reading that portion, that they had decided to implement that. Therefore, I was just saying that, all right, they decided that after...
We have not decided to implement what my friend is saying, my lord. We are simply saying...
It is there, show cause, it is there, Your Lordship.
In my order, we have passed
Can you kindly see the order?
Yes, the order, if Your Lordship...
Senior Counsel, assessed by so-and-so, has fully submitted after contempt application has been filed, the representation of which has since been disposed.
That is all right.
He that he may be...
No, that is not there. That portion I never asked for. I didn't say it. He praised that he may be allowed to explore other remedies. No other remedies remain. It's only that attained finality in the Supreme Court. So I cannot have any other remedies.
Do you think that your contempt was non-disposal representation, correct?
Repetition, no. Non-compliance with the order of the Supreme Court. Repetition was not there. Your
Then you file a fresh contempt.
The contempt, there is no review, my lord. What review can be filed in?
No, therefore, only I want this. He praised that he may be allowed to explore other remedies. That may be deleted, Your Lordship, because otherwise it will go a wrong signal to the Apex Court order. That's what the petitioner decided.
What signal the Apex Court?
Apex Court order.
No, because otherwise what is happening, Your Lordship, because contempt there, although this up to the contempt under Your Lordship.
Yes.
That's obviously. But however, it seems that according to the petitioner, they still having fallen in contempt. That being the reason. Therefore, they are making a prayer if can be restored.
Fresh contempt.
There is no...
All right. That can be.
This is review is not maintainable, my lord. There is no error apparent on the face of record.
My humble submission.
Then you file a appeal for deletion of that.
Therefore, this review, I have filed this review. I have filed this review, Your Lordship. The prayer I have seen at page 5, Your Lordship can say that. On the prayer, Your Lordship may be pleased to call for records of the dispose of contempt case number so-and-so. After hearing the parties, be pleased to remove.
Dictated open court.
Yes, it is open court. Your Lordship, that time when Lordship dictated it and both of us were making noise. I'm sorry, extremely sorry, Your Lordship. That's my
court responsible for that.
That was inaugural. I should have corrected immediately, but since we are talking about that, he said they fraudulently taken. Then I was just talking to him. That time, Your Lordship was possible.
Submission, if I correctly remember, was that when we filed a contempt.
After that, they disposed.
After we had a contempt, so the contempt can be closed at this stage. That's all. That other remedies, whatever granted. Why agree with that?
No, that may be deleted, Your Lordship, because I didn't say that, therefore, only for that.
Why they holding you to accountable for that?
Yes.
Your client.
No, I feel bad also because I didn't say that then.
If we listen to clients all the time, then
no,
the fear of lawyers.
No, it's not that, Your Lordship, I understand. But since it was not fallen from my mouth, I think if Your Lordship is pleased to delete it.
But that was what was conveyed.
No, I didn't say. I said that time, Your Lordship, that a time-bound period may be given. Only that I said, time-bound period may be given.
Then we will keep it. I'll just examine that YouTube. This is matter next week. Yes.
Item number 2.
Yes, the prayer of the parties is meeting next week. Okay.
In fact, the notices are already he has received.
No, it's,
Much obliged. Make this yours.
Yeah.
My lord, this is a contempt petition, my lord, against the willful and deliberate disobedience of the order passed by this honorable court, my lord. My lord, if your lordship recollect, but this order was passed very recently, my lord.
where is the order? Is the order of the council?
No, no, my lord, the order passed by this honorable court, my lord. Annexure 4, my lord.
Yes.
Page 55, my lord.
Annexure 4?
My lord. Very short order, my lord.
Yes. Yes. Okay.
My lord, the status quo order was passed by this honorable court, my lord. My lord, what had happened is that after this order was passed, since I was in possession of the suit land, my lord, I was working on it. And on the next day, very next day of the passing of the order, the respondent had come to the suit land, had stopped me from doing any work. In this regard, I have filed FIR also, my lord. 2 FIRs were filed by me. That is on 3rd July, 7th July and 8th July, my lord. There's Annexure 5, my lord. Annexure 5, plus I have annexed the photographs also where I had undertaken work in the suit land, my lord. They have been stopped by the respondent to undertake any work in this suit land.
So status quo means I don't think you can start any work.
No, no, my lord, I was in possession in that particular.
Status quo means status quo. That's why it's very confusing. Where's the suit's pending? Correct.
Suit is pending, my lord. My lord, what had happened is that the respondent had filed a suit.
No, we get it. Only thing is that now status quo means what? Doesn't mean you're supposed to do anything also.
My lord, I am in possession of the suit land, my lord. I have been working on it, my lord, all along.
The issue notice. Well, what you started to build structures or you building?
No, no, my lord. This is just pillars has been put on, my lord.
Not pillars. These are bali posts.
Bali posts, my lord.
You're building a house.
It's a small shed, my lord, actually.
Okay, you heard Mr. Elkrim issue notice returnable in 2 weeks. Yes. Steps to be taken within 3 days.
Troubles.
The status quo. If the matters for civil court, let the outside appear. Then you know,
it's an admitted fact that I am in possession, my lord.
Item number 3.
Yes.
Plus, this matter I was praying if my lords kindly have it tomorrow, my lords. Some instructions are yet to be completed. They were also supposed to praise some instructions.
Monday?
If this tomorrow, lordship, tomorrow.
Let it be kindly be tomorrow.
Station again.
No, my lord, some matters are now coming up in Supreme Court again and again. Boundary dispute was listed yesterday, so that boundary.
Short motion. Obliged.
Daily list item number 1.
To request of the parties, this is a matter tomorrow.
So this matter, Lordship, I'm praying for some accommodation, Lordship.
Where's your junior colleague?
Lordship, he's here, Lordship.
Yes. You want time here? Yes. So now you've well instructed. You don't mention no apologies. Okay, it's all learning process. Yes. Especially for junior, it's very important that you observe court proceedings. You know what is the procedure, what is the decorum. That's very important. Yes. When? Tomorrow?
Let me next week, Your Lordship.
Okay. That request of just after 1 week, yes.
Applies.
Item number 2.
His Lordship. Private respondent, I find my objection, Your Lordship.
Yes.
for admission, but
JCDC, I don't know whether. Why?
The conducting counsel is having some personal difficulty, Your Lordship.
When is he coming back?
On Monday, Your Lordship.
After 1 week?
Yeah, after 1 week, Your Lordship.
I pray to allow us to file the affidavit.
What's the matter about?
This is regarding the clubbing together, that case of two separate cases. Two separate cases was going on before the EM and the CM. They want to club together.
Yes, then let them file affidavit then. Mr. S. Dev for 1 to 4. Please, once allowed. 2 weeks time to file affidavit, yes.
Hello,
Item
number 3.
Your Lordship.
Yes, Mr.
My lord, the contempt petition against the order dated 1/5/2024, my lord.
Lordship, I'm praying that the matter can be taken up next week as the DHI is not keeping well and he's
Mr.
not
Dr.
available.
Muska is not well. Yes, after 1 week as the DSTI is stated to be unwell, yes.
Highly obliged.
My lord.
4.
This Lordship, this matter they are not going filing the affidavit. Lordship, in the division bench they make a statement that they are actively considering the case. But however, I got an instruction, nothing was there. They have not even communicated.
Just fooling you.
The petitioner only approached us.
No. I have never approached. I never make a statement, Lordship.
A statement that
what
you
had
have-
happened,
no,
Lordship?
That's under active consideration.
No, it is an issue of reinstatement. So the petitioner was informed that if he tenders an apology, and we'll reinstate him and put an
You're
end
going
to
to
it.
apologize?
Nothing was communicated, Lordship.
Suppose you're going to apologize now, will he'll give his job back?
We are saying that he is not coming forward. He wants
No.
to
There is no
contempt.
communication. They are only making a statement inside the court. I have never get any information or intimation
Now you hear it. It's inside the court. It's more
yes,
sacrosanct than
Lordship, that may be recorded. The statement of the because they are making a statement that if I apologize, they will reinstate my service.
Will you apologize?
I will apologize, but provided that statement may be recorded, I will write and apologize.
Record a statement.
Provided that let them.
It may be recorded. There is scope of settlement as is recorded in the.
Should not divert. There is not a scope of settlement. Provided I will definitely apologize. Let they are saying that I will apologize.
According to them, you are the ringleader for the strike.
Not at all. It is a matter of proof, Your Lordship. This is just an allegation. Even now, I'm out of service. Even then, all the employees are agitation is going on. They cannot. Every time when agitation come, they're saying I'm instigating. I'm no more at this.
Let it be taken up on 31st along because the writ appeal is also on the same date. In the meantime, if it is settled, Lordship, that can be a end to both the matters.
If we record it, if he goes and apologizes.
Let him approach, Lordship. Let him approach for any settlement.
Mr. S. Deb submits that the matter has been under active consideration, and the petitioner will be advised to approach the respondents
for settling it out.
Yes.
For settlement talks. Okay.
Lordship.
So, PT Sangma agrees to the suggestion made by the counsel for the respondents. Accordingly, list after 2 weeks.
Lordship.
To await any outcome.
Yes, Lordship.
Obliged.
I'll make an effort.
Folded hands.
Item number 5.
Provided if they're giving reinstating, I have no problem, Lordship, because they have already reinstated other people who have been already terminated. They suspended for the same course of action. They already reinstated. It is on record, Your Lordship.
They were only suspended and reinstated.
Yes, even me for the same course of action. They have terminated me.
You were terminated.
I was terminated.
Yes.
Obliged.
Much blessed, Your Lordship.
5.
Five and 7. Anyone appearing? 5 and 7. 5 and 7 is. They've been served, correct?
Regional Director.
They've been served.
Item number 7.
Response 5 and 7, they've been served.
We served it. Yes, Lordship. We served.
There's no response number 7 or 7 years. You are appearing or no? Yes. No, you are appearing, Ms. Burchang, for the NHI. 36.
For respondent number 1 to 4, Your Lordship.
Okay. Have you all filed affidavits?
Yes, Your Lordship.
You'll file?
Yes, Your Lordship.
You already filed?
Yes, Your Lordship. We already filed.
Yes. Who has filed affidavit?
The state, Your Lordship.
You want to file affidavit? No appearance made on behalf of respondent 5 and 7. So it is stated that they have been served. Ms. Emerchang on behalf of respondent number 6. You want to file affidavit?
I'll take instructions.
Please be allowed to take instructions as to whether after it needs to be filed just after 2 weeks. Yes. And for rejoinder,
Yes, Lordship.
rejoinder also to the after filed state offence may be filed by the petitioner. Yes.
Item number 6.
Yes, Your Lordship.
May it please, Your Lordship. Lordship, respondent number 4 are yet to enter appearance, Your Lordship. Lordship,
They've been served.
no, Your Lordship, yet to be delivered, Your Lordship.
Very smart submission you made. Here recorded you haven't filed affidavit.
Lordship, has not been delivered. Lordship, has not been delivered, Your Lordship.
Don't take fresh steps.
Yes, we have taken fresh steps, Your Lordship.
You've taken fresh steps or you want to take fresh steps?
We have taken fresh steps, Your Lordship. And
Yes, claim submits that praise that matter will be set after 2 weeks to a certain status of service or respondent number 5. Have you filed affidavit?
we have filed, respondent number 4, Your Lordship. Respondent number 4.
Sorry. You filed. You already filed. Yes, sir. Yes, list after 2 weeks. Yes. After 2 weeks, petitioner to a certain status of service and to file affidavit necessary.
Item number 7.
Item number 7, I am appearing on behalf of Mrs. R. Datta, Lordship. This is a legal aid matter, Lordship. So we were supposed to file rejoinder, Lordship. Lordship, in view of the mediation drive going on, Lordship, this matter can be referred to the mediation, Lordship.
For the same,
because, Lordship,
Yes, parties submit that the matter perhaps can be put up for mediation. Accordingly, the matter be placed for the mediation committee, for further necessary action. Is
Lordship.
8.
Lordship, this connected matters, Lordship. 8 and 9 are connected matter. Here, Lordship, they have filed their affidavits, Lordship. I am yet to file the rejoinder.
You have to file rejoinder, Lordship.
Contempt rejoinder.
In the main,
notice was not
issued, Lordship. In view of the stay, Lordship.
Yes, 9. Item number
8 and 9, Lordship.
9. Mr. Chanda prays for further 2 weeks and file the rejoinder. Praise allowed. This after 2 weeks. This contempt is together with that main requisition.
Right. Obliged, Madam.
Item number 10. 10.
May please, Lordship. So both party they have filed affidavit. However, I pray that this is also fit case to send it for the mediation because I'm not the wife in this petitioner and the other.
First wife or second wife?
I'm the first wife actually, but the claiming is relatives, mother and the mother and the niece of the deceased.
I'm the mother and the niece of the.
You're the mother and the niece.
5 and 6.
And
5 and 6. Yes.
no second wife.
No second wife. So I'm praying.
They come for mediation.
I will listen. She will come.
Yes, parties submit that this matter also perhaps will be put up for mediation. So accordingly, matter will be placed on mediation committee. Yes, for
Lordship.
Let's see for the action.
Lordship.
Much obliged, Lordship.
Much obliged, Lordship.
11.
Lordship, here. Lordship, this is that arbitration application, Lordship, wherein the respondents were supposed to file their objection affidavit, Lordship.
Lordship, we've not received instructions still yet. I'm praying for some more time.
What to do?
Lordship, this has been the 4th occasion, if I'm not wrong, Lordship.
MS Emerson submits that till date they are yet to receive instructions in the matter. Stop. Is this a delayed arbitration or is delay?
Lordship, they say, Lordship, that there's a delay. However, Lordship, there's no delay because, Lordship, time and again, Lordship, after the completion of work, we have been written to them, Lordship, for clearing our pending views. Thereafter, we have written for invocation of arbitration also, Lordship, but they have not done anything. In fact, they
You're saying that the application will not lie anymore under Section 11.
They are saying that they are saying, Lordship, that it is barred because of limitation, Lordship, and that is their primary stand, Lordship.
They're still yet to receive instructions in the matter. Stop. Who's supposed to get instructions from?
Lordship, it is the GE garrison engineer, if I'm not wrong, Lordship.
Chief engineer.
Chief engineer. Chief engineer.
Or chief engineer? Or from the engineer in chief in Delhi?
From the chief engineer, Lordship.
Because the work was executed here, Lordship. So
Garrison engineer.
Lordship, garrison engineer.
Stop. It is noted that apart from respondents number 1 and 2 who are not based in Shillong, the rest of respondents are located in Shillong itself. Stop. As such, not understood why instructions are yet not received. Stop. This is a matter of 2 weeks. If the instructions are forthcoming, respondent number, that is, will be the respondent number 5.
Lordship.
Shall personally appear in court to apprise really. It's up to 2 weeks. Yes. Copy of this order be given to the counsel for the respondent. Do we actually learn or something? 2 minutes.
Item number 12.
Please, Lordship, we will file the affidavit today for 1, 2, and 3.
I have filed my objection to the miss case and also to the main petition also I filed.
What's the matter about?
This is regarding the this injunction order was passed by the EM. So they have, without filing an appeal before the CEM, they have directly come and challenging the
MSEM.
She's on leave, Your Lordship. Your Lordship, rejoinder is required, Your Lordship. I pray for 2 weeks' time.
Affidavit has been filed by to the main case. To the main case you filed, Mr. Deb.
We will rely on this for the...
Yes, has been filed in the main application. So Mr. P.T. Sangma submits that to the connected miss case and affidavit has already been filed.
Yes.
Ms. Absang, you want to file a rejoinder in the miss case?
Yes, Your Lordship.
Yes.
Both, Your Lordship.
Why you filed 2 affidavits?
No, there is one miss case they have filed for stay. So I filed an objection to that. Again, that another affidavit was filed on the main case. That is, there are 2. They have filed 2.
No, you filed 2 one in the miss case and one in the main case.
Yes, one in the main case.
But both of them you written miss case in the affidavit.
Due to mistake, Your Lordship, I will be allowed to correct it because that on top, Your Lordship, it is due to some bona fide mistake. Just
See, don't be in so much a hurry when you prepare petitions. That is, make sure that it is in the right form.
Lordship.
It creates just problems for the office also. No, by all the respondents. Stop. However, Mr. P. Sangma submits that due to inadvertent mistake, they have both affidavits have been filed in this case. Stop. We please will have to correct the main affidavit.
We have received only one set of affidavit, which is titled in the miss case, but in the was titled is written reply to the writ petition.
Is that
is the one?
Already correct. That's
see, it's filed 2 affidavits.
There is no 2 separate affidavit for the miss
no,
case.
it's already there. Before earlier. Earlier, not today. Earlier. Yes. The last occasion it has been filed long by.
Yes, Mr. Sama.
Yes.
Perhaps not, sir.
You are.
That earlier one is already filed long by. This one is filed.
Second one filed in miss case.
The second was.
And why is written here?
Yes, that's why I said there was a Lordship. That's why I'm saying there was a mistake in the main affidavit in opposition.
Reply to the aforesaid writ petition.
That miss case was already filed in the month of June. It's long back.
So you've not filed the main petition. That means.
Yes.
Still trying to understand what you have done. You file affidavit in WPC number 89.
Yes.
That is pray for stay.
Yes.
And the around 94. Have a look Have a look at this, what you've done. Or you withdraw this affidavit and file afresh.
We'll withdraw it, Lordship.
Just see it first. See the cost title you've written there. Have a look at Mr. Deb. Just kindly help your.
Yes, this is.
Just kindly help him also.
Only in the court P we have made a mistake. In the stamp report. This is correct.
In the code fee, what do you mean?
No,
See the cost
in the
title.
stamp report. In the stamp report.
See the cost title, Mr. Sangma. See the title on top.
So this is in miscase or repetition?
No, this is the repetition.
Now look at next affidavit again. You have filed 2 affidavits.
This is the repetition. This is the repetition.
And that first affidavit you say? No, the other one. 19 June.
This is the miscase.
19 June is in
miscase. What is the miscase?
Repetition.
Oh yes, this should be miscase.
I think, Lordship, the affidavit filed on.
Yes, there is mistake in both miscase and this one in the third course. It should have been the written miscase.
Affidavit has been filed by the number one. Affidavit has been filed by the. This is respondent number. You are Mr. Deb.
1, 2, and 3, Lordship.
1, 2, and 3 remaining petitions. But however, while examining the affidavits filed by the respondents 4 and 5 in the 2 mills applications, it appears that the same has certain defects. According these affidavits are returned to enable the respondent to file afresh. Yes, for 2 weeks. Please be careful, otherwise there's problems.
Published.
13.
Much less.
I will make you pay cost. Yes.
Lordship, this is that risk purchase matter, Lordship. Respondent number 2 to 19, Lordship, was supposed to file affidavit, Lordship.
We filed, Lordship.
It's already been filed?
Yes, Lordship.
When?
We have received it on 9/7/2025,
Yes,
Lordship.
So what do you want now? Ready for hearing?
Lordship, no. We'll reply to the affidavit, Lordship. It's a detailed affidavit, Lordship, they filed. In fact, Lordship.
What's the matter about?
This is here, Lordship. What is
raising the
risk?
Mr. Khera's there.
He's somewhere far away, I think. Can't hear him. Yes.
If primary raised on the maintainability ground, Lordship. That arbitration clause is there, conciliation clause is there.
Lordship, this matter is covered by your Lordship's judgment, Lordship. Earlier also, there's one matter with the name of Pioneer Carbide, Lordship. Lordship has dealt with the matter and allowed the writ petition, Lordship. So, we'll assist your Lordship. Let us, in the meantime, reply to the affidavit, Lordship.
Okay, I understand. Is the risk on purchasing?
Lordship.
Yes, you don't file rejoinder?
Lordship. Small rejoinder. If
please is allowed to file rejoinder to the affidavit filed by the respondents 2 to 19.
2 to 19.
Praise allowed this up to 2 weeks. Yes.
Hello.
14.
Yes.
Lordship, here I pray for further 2 weeks time, Lordship. I'll file it.
Objection?
No, your Lordship.
No objection.
Objection.
Government.
Last chance may give in your Lordship.
I'll file it, Lordship, within that period.
Yes. Mr. S. A. Sheikh responds out for a 2 weeks time affidavit. The expected next day the affidavit should be on board. Yes, accordingly.
Objection. 17.
My lord.
Your Lordship, I think last question I've given this, I will not be
appearing anymore.
What more chance may be given, Lordship?
Chance to whom?
To the petitioner, Lordship.
Dismissal of default.
Because I am not having any contract.
There's no contact, no instructions, correct?
In fact, there is nothing in this writ petition, Lordship. There is nothing.
There's nothing.
There is nothing in this writ petition.
Now, what are these papers then?
But still, one more chance may be given to the petitioner. In the meantime, they might engage counsel.
He is working, what areas of salary? You're working for the state?
No, Lordship. For the private husband, Lordship here. He was claiming some dues, Lordship, for a period, Lordship. That has already been settled, Lordship, in earlier round of litigation, Lordship. They have filed contempt.
Yes. Mr. Your Lordship, I am not having any contract, and whenever time was so, that's why last question I have made submission, Your Lordship.
And in fact, matter is referred for mediation.
No.
One more chance may be given if on the next day.
Though Bisad did not disengaged himself, counsel, the petitioner appears has not engaged any fresh advocate stuff according to registry to issue notice to the petitioner.
Must
to engage fresh counsel if necessary. Yes.
Item 23, matters referred to special mediation. 23.
Yes.
My lord. I have a...
Is it matter regarding pension or what is it?
No, my lord, it is with regards to the grant of ACP and MSCP, my lord.
Can it be done by mediation?
Lordship, I don't have instructions, Lordship.
You agree or not to go for mediation?
I don't have instructions in that regard, Lordship. If Your Lordship can kindly have the matter next
in
week.
the appropriate bench. Next date, yes.
24. 24.
See, both sides have to agree at least, then you can sign the bond and appear on that appointed day. This one, Mr. Sen, agreeable?
May it please Your Lordship, may matter be called. The end of the board, Mr. Sen is on his way.
Just for whether he agrees to be sent for mediation or not, that's all. Agrees?
Mr. Sen will be coming, Your Lordship.
They have challenged our appointment, Your Lordship, subject to whatever the petitioner has to submit.
Okay, after some time.
25.
No mediation in this matter, correct?
No.
Not agreeable?
Not agreeable.
No. List the matter after 1 week for hearing. The party is not agreement for mediation, just after 1 week for hearing.
26.
Your Lordship, I was praying for me to be appointed in the regular post on the ground that the land was donated by my father.
Are you open for mediation?
Petitioner is willing, Lordship.
Yes.
It depends on the managing committee and the...
Yes, managing committee.
Yes.
Can say. The parties are agreeable to refer the matter mediation.
As far as this state is concerned, my lord, I have no such instruction.
Yes, as a party agreeable to go for mediation, bond will only be signed. Yes. You sign the bond.
My lord, my respectful submission, my lord. As far as the state is concerned, I have not received any consent, my lord. That is the difficulty.
If the main respondent is you, correct?
Yes.
27.
We can try once. Let's.
Of course.
Dear my lord, I think my friend has already received some instruction saying that I am entitled, my lord, under my pensionary benefits under the old scheme. So the issue does not survive for reference to mediation.
Lordship, close it.
Lordship, may I file an affidavit, keep it on board so that matter can be disposed of accordingly?
Or you can go before the meeting committee.
No, my lord, it is no longer subsists, my lord, that question.
Okay, yes. Yes, Mr. the counsel for the parties submit that as a matter of the closing stages, be listed after 2 weeks to enable the learned government advocate to put the instructions on record.
Lodge. Deeply obliged. Much obliged.
28.
We are agreeable for sending the matter to the mediation, Lordship.
I am for the Union of India. State is the main.
State is the main respondent, Lordship, in this matter.
Where is the state? Yes, Bharatji.
I think, Lordship, as Bharatji
No,
on leave, she's on leave.
She's on leave, no? Send for mediation.
We are agreeable, Lordship.
This petition is only for the disposal the represented by the petitioner. So
No, Lordship. That is incorrect, Lordship. Here we are.
Are you agreeable to mediation? Yes.
29.
Ordered accordingly. Yes. Ich habe sein Begehren bleiben. This one?
Lord, in this matter, the petitioner is seeking for my termination, so there can be no mediation on this.
Suppose, sir, he's seeking for a termination.
My lord, after 12 years. So, my lord, there can be no mediation.
And compensation from the state.
No, then. Yes, after 2 weeks. Yes.
30.
As the mediation prospect is not, as mediation prospect is not possible, just after 2 weeks. Yes.
This matter, Lordship, if the private respondent is ready to pay some amount to the petitioner, Lordship, then it can be settled.
Lordship, the respondent number 4.
This is a good matter for mediation.
Yes, listed is there.
No, that you settle mediation. Settle mediation.
Yes.
Right? How much you'll pay?
At least
the parties agree that the matter. Yes, it involves terminal benefit. Parties are agreeable to try for mediation.
Yes. Is there.
31.
Much less, Lordship.
Ordered accordingly. Yes.
This can go for mediation, my lord. This is regularization, my lord.
The department has also agreed, my lord. I have met them.
Parties agree for mediation. The matter ordered accordingly.
32.
My lord, 32 can also go for mediation. This with regard to pension, my lord. Subjected the union are willing to come, my lord.
Here, Lordship, subsequently I have implemented the Union of India, my lords.
That has been allowed, my lord.
Where's the
If the union is willing to come, I believe the case will be sorted out.
I have taken a step to the Union of India, Lordship.
But have they appeared or not?
No, Lordship.
They have not appeared.
Not yet.
It was on the last occasion only.
That's all, Lordship.
Yes, after 2 weeks, yes.
33.
For the orders, yes.
Also, here, Lordship, the petitioners are praying for regularization of their service. So
I have spoken to the department, my lord, but then I have not received any consent, my lord.
Let's go for
Yes,
mediation.
just after 2 weeks, huh? For the orders, yes.
Problem.
34.
My lord, this relates to promotion, my lord. There was a transfer where I've lost my promotion. This can go, my lord.
I will give it a try, my lord.
You agreeable?
Lordship.
Parties agreeable for mediation, order accordingly.
Team link.
5.
My lord, 35, there's some my lord, complicated question of law. So, my lord, it's better.
Yes, as substantial complex questions of law are involved, parties pray that the matter will be listed for hearing.
Obliged, Lordship.
In this after 2 weeks, yeah.
36.
Yes.
My lord, the
open
issue.
mediation?
Yes,
The issue here is, my lord, regarding service benefit under the old pension scheme. When he was regularized, when the new pension scheme came into existence, I don't see, my lord, it can be sent, but for the satisfying the petitioner, my lord, we are willing. However, I don't see it will
Parties
be.
agree that an attempt at mediation can be made. Order accordingly, yes.
37.
So this matter pertains to regularization, Your Lordship. So we're ready for mediation.
Can we mediation? Yes, same order. I'm surprised that so many matters go to mediation.
38.
My lord, in 38, my lord, I've been informed by the learned AAG that there are some developments which, my lord, resolves the issue. So let this matter come up for hearing, my lord. We'll...
As a party submit that as the matter is perhaps the end resolution.
Yes.
Yes, listed for hearing on.
This is ACP and ACP.
After 2 weeks, yes.
Deeply
39.
Lord.
My lord, this matter relates to the pensionary benefits of her deceased husband, and in the meantime,
Go for mediation.
she's ready to compromise, my lord.
Party is going same order. This party is
Obliged.
Yes.
40.
This case, Lordship, that this is the wife of the Home Guards, Lordship. The similarly situated Home Guards, they have received the revision of pay benefits, Lordship. So, if the states agree.
You agree with mediation?
Yes,
Yes.
Lordship. Yes, Lordship.
You can please the orders
Yes.
pass. Orders accordingly.
41.
Yes, Lordship.
Yes.
This matter relates to the paid.
Yes. What's the matter about?
It's regarding rank and pay structure, Lordship.
Yeah, open for mediation? No.
I have no instructions, Lordship.
Yes, this is matter for after 2 weeks.
42.
My lord, this matter is regarding the pensionary
Your Lordship, in
benefits.
this matter, already paper is sent to the CDA. So I think it will not be required to go for mediation.
It won't go.
It will not go. Your Lordship. If the pensioner pass.
Party submit as a matter is by itself the real resolution. Stop. Them will be heard when?
Your Lordship, already
after 1 week.
Yes, my lord.
No,
after
it is
one week.
already it is fixed, Your Lordship.
It's fixed on the 16th of August, my lord.
What you get is it fixed on? Yes.
Highly obliged, my lord.
On the
Sec-
date fix, yes.
Second call. 24.
It can go, Mr. Sen.
My lord, this is a matter, my lord. I am the recommended candidate. I was not.
Can I go for mediation? No.
My lord, I know. If my lord, otherwise, my lord, what I suggest, only solution is, my lord, if they create a post and accommodate, because I am the recommended
You
candidate.
ready for mediation?
Here, Lordship,
Yeah, for whom?
my appointments are challenge. I'm for respondent 9, private respondent.
Then no mediation. As the parties are agreeing mediation, this for this under.
This is already fixed, my lord, 4th.
On 5th of August.
Date fixed.
Yes.
Already fixed.
5th, yes. Hearing?
Lordship, indulgence, Lordship. In item number 13, Lordship, there is an interim order, Lordship.
30?
Item number 13, Lordship. Due to Indian.
Send for mediation.
No, Lordship. I am praying that interim may be extended, Lordship. Due to
For mediation.
No, Lordship.
13 or 30?
Item number 13, Lordship. There is an interim order, Lordship. By due to inadvertence, Lordship, I am not.
I am sorry, my lord. I am sorry, my lord. In item number 41, my lord.
Yes.
This matter relates to pay and rank.
No, there's no way. We are hearing it. We are no mediation. These matters, yes.
My lord.